Hello all. Uh, Again I am back with another aspect of discussion. So today I am going to take up the discussion on something which going to deal with speedy and amicable dispute resolution. I will start with one statement as to the kinds of laws. The laws are of two kinds, substantive and procedural. The substantive law provides for the rights, liabilities of the parties, but whereas procedural law provides you the procedure through which you can enforce those rights and liabilities. So, when we talk about procedure, the procedure should concentrate upon the important requirement of proper justice delivery system. So, when I talk about justice delivery system, it has to ensure that the justice is delivered at any cost. Now, when I talk about justice at any cost, I come across with two important and interesting maxims. So, all this time we are discussing about access to justice, and today I am going to discuss about speedy and amicable access to justice. So, when I talk about speedy and amicable access to justice, the maxim which says that justice delayed is justice denied. Now, that is the reason why we need a speedy disposal of case. But at the same time, there is another maxim which mentions that justice hurried is justice buried, which talks about justice should be the paramount importance, should be given a paramount importance rather than the speed. So, here today we are talking about civil procedure code, which tries to bring out a nice balance between speed and justice, which try to answer both the maxims. Justice delayed is justice denied, as well as justice hurried is justice buried. Good morning all, myself Dr. B.S. Patil. I am working at V.M. Salgaonkar College of Law as assistant professor. My college is situated at Goa, and I am very happy to present to you speedy and amicable access to justice, the experience of Code of Civil Procedure. First, let me deal with the learning objectives of this whole process. So, today when we take up the discussion on speedy and amicable justice and CPC, we are trying to assess how CPC provides for speedy and amicable settlement processes. And when we study CPC in this aspect of speed and amicable, we come across with many processes which suggest it, like summary proceedings, special suits, special proceedings, then interestingly section 89 of CPC. So, these are few important areas which I would be browsing through. In addition to that, I would be checking into few of important Supreme Court judgments, where the judiciary is trying to explain the importance of speedy and amicable settlement of the dispute. Now, before I take up the discussion on this, let me put forth a point to your notice that some of the provisions may concentrate on speed, may not be amicable. Some will concentrate on both speed and amicable settlement of the dispute. But for the sake of discussion, I have picked up both the aspects of CPC which talks about speed as well as amicable settlement of the dispute. Moving on with our discussion, when we talk about Code of Civil Procedure, this civil procedure code supposed to make efforts in resolving dispute. So, when we say effort by CPC in resolving dispute, I meant to say that CPC should lay down a procedure through which a dispute could be resolved without much delay or without miscarriage of justice. But when we talk about today's topic, the role of CPC is going to change from establishing foolproof procedure to decide a case, where a judge decides after hearing both the parties, where the judge pronounces his decision after completion of the trial. Today, a judge is going to act to assist parties to arrive at a settlement. Here the judge is expected to provide assistance to settle a dispute which is just, fair and lasting, and also it is an effort by the court to reduce the burden on the court. It is going to be one important answer to the question of this millennium, that is docket explosion. So, when we talk about access to speedy and amicable justice, there are various aspects to this under CPC. One is friendly suits, where a suit looks like a discussion between friends. There is withdrawal of the suit, where a person withdraws because he does not want to continue with. There is a compromise of suit, where parties file a suit, but at the end they decide to compromise over that issue. A suit where state is a party and state is trying to negotiate and settle the dispute. We have suits where defendant has got no right to argue the case, it is only the plaintiff's job to establish the case and take up the decisions. Looks to be quite path breaking and revolting kind of provision, but when we go through that provision, we find that there is a justiciability behind this approach. So, let me take a first one, which is special suit. When we talk about special suit, in this special suit there is no presentation of plaint. Any question of law and fact which arises between them, between the parties, instead of one party running to the court, filing a plaint and expecting the other party to answer to the plaint, here both parties would come and discuss, saying that these are the issues that are raised between us, maybe a question of fact or maybe a question of law, and what to do with these issues. They decide to go before a court and submit to the court an agreement between the parties, where they enumerate that the kind of confusion they have come across with. So, here I am talking about a situation of not a dispute resolution, but confusion clarification. It is possible where the parties have confusion which needs to be clarified. If it remains unclarified, that confusion may lead to dispute. So, therefore, here we have a provision where the two partners in a business or the two friends can come up with an agreement and present to the court, requesting the court to decide on that question. The advantage of this provision, where they come to the court and request the court to decide the question, there is no appeal against the decree of the court. It eliminates further future dispute, it brings out better relationship between the parties, it encourages amicable settlement between the parties, and as I said, it is one of a small step for avoiding docket explosion.